Hey everybody, it's Mike Kennedy, Vermont Bar Council. Welcome back to the garage, my garage, for another in the garage series of CLEs. Today we're going to be talking about trust accounting, part 3 in the trust accounting series. Today, collected funds and dispersing funds. It's a beautiful morning here at my house, Williston, Vermont. Clear blue skies, bright sunshine. Got the garage door open today. Hopefully that doesn't pose any problems. But anyhow, let's get right into it. First, of course, before we get into it, I hope everybody's staying safe, staying healthy, being good to each other, being good to yourselves. So without further ado, the trust accounting presentation, I'm going to pull it up on my screen. You know, I don't like to jump right into things, so here's what I'm going to do today. Sorry, there we go. So there's the title, Trust Accounting Part 3, Collecting and Dispersing Funds. Now, first, this is a picture on the right. This is a picture that's in my garage. I took a picture of it and put it on in the presentation to wish somebody a happy birthday. And that is Jane, my dad's wife. Today's her birthday. She took that picture. My dad and Jane live in Flat Rock, North Carolina, which is just outside of Hendersonville, about 2 hours west of Charlotte. They used to live in Virginia on the Chesapeake, and that's where that picture was taken. That's me, the first time I ever caught a crocodile. Jane helped me catch it. I just had that little rod, didn't even have my own gear, and I caught the croc. And Jane was there to document the occasion for me. So yesterday was Jane's birthday. She watches these videos sometimes, even though she's not a lawyer. Jane, happy birthday. Now that's a croc. Okay, we're going to do a pre-test today. There's 7 questions to see where you stand on collected funds and dispersing funds. We'll go over the answers at the end. For those of you who need proof that you took this video to get CLE credit, depending on your jurisdiction, there is a link at the end to Google Forms where you can take the quiz, then it'll spit back to you the results, and you can use that as sort of a certification. Anyway, question 1. A lawyer shall not disperse funds held for a client or third person unless the funds are, and I'm looking for the exact phrase used in the rule. I've already said it 3 or 4 times. Is it A, good funds, B, collected funds, C, certified funds, or funds that are on deposit? What does the rule say? I'll go through the answers at the end. That way, during the presentation, you can change your answers if need be. Question 2, with respect to the general rule not to disperse until a deposit has been credited to the trust account. Notice I didn't give away the answer to question 1. The PRB's hearing panels have interpreted the rule. Is it A, strictly, B, loosely, consistently suggesting that the rule is overbroad and should be amended, or is it C, they haven't? There's never been a prosecution under the rule. We adopted the rule in 2005. Why would Mike include this question in a CLE? Should be a hint. Question 3. Which of the following do the rules prohibit a lawyer from dispersing against upon deposit to trust? So 3 of the instruments I'm about to read off that are listed there, a lawyer can write against upon deposit. There's 1 a lawyer cannot write against upon deposit. The lawyer has to wait for the funds to be credited to the account. Which one does the lawyer have to wait for to write against? Is it A, an IOLTA check issued by another attorney licensed in Vermont? B, an IORTA check issued by a realtor licensed in Vermont? C, personal check from client in the amount of $1,900.99? Or D, a check issued by an insurance company licensed to do business in Vermont. One of those the lawyer has to wait. The other 3 the lawyer can write against upon deposit. So cool out this morning. You might be able to see the steam coming off my coffee. Beautiful day. Question 4. One purpose of the rule against dispersing before funds have been credited to the trust account is what? Is it A, trick question? There's no clear purpose behind the rule. Is it B, to keep lawyers from using client A's money to fund client B's business? Is it C, to comply with Vermont's DFR regulations? Or is it D, to comply with FDIC regulations? Why would we put a rule in that requires a lawyer to have funds credited to the account before dispersing from the account? Or did we put it in for no reason at all? Question 5. Upon receiving funds in which a client or third person has an interest, a lawyer must do what? Is it A, assess whether a reasonable lawyer would notify the client or third person? B, notify the client or third person? C, promptly notify the client or third person? Or D, watch the movie Rounders with the client or third person? Probably not D. I don't think that any movies are mentioned in the rules of professional conduct. I can check, but I'm pretty sure none are. But there's a reason I put that in there. Question 6, and I know I'm going quick, but we're going to go through these at the end. Is this true or false? The rule that requires a lawyer to hold in trust any funds to which a third party asserts a claim does not apply to the lawyer's own claim for fees. That is, a lawyer can always remove a disputed fee, even over the client's reasonable objection. So as we're going to talk about, there is a rule that at certain times requires a lawyer to keep in trust funds to which more than one person assert an interest. Is it true or false that that rule does not apply to the lawyer's interest in those funds? Neighborhood's starting to wake up, seeing people out and about. That's good. Question 7, last one. The mere assertion of an unsecured claim by a client's creditor to funds that the lawyer is holding in trust for the client. Is it A, triggers the lawyer's duty to keep the funds until the dispute is resolved? Or B, does not trigger the lawyer's duty to keep the funds in trust until the dispute is resolved? So as I just mentioned, there are going to be times when a lawyer is holding funds that somebody else asserts an interest in. Does the mere assertion of an unsecured, and when that happens, a lawyer may or may not have a duty to keep the funds in trust until the dispute is resolved. Does the mere assertion of an unsecured claim by a client's creditor trigger that duty or not? Okay, here we go. The rule in Vermont, Rule 1.15F, adopted in 2005, a lawyer shall not disperse funds held for a client or third person unless the funds are collected funds. That's the actual term used in the rule. What are collected funds? Well, the rules define collected funds as those that a lawyer reasonably believes have been deposited, finally settled, and credited to the lawyer's trust account. Now, I know that sometimes that's hard to assess. Even when you call your bank, they might tell you that there's no clear answer. The reporter's note to the 2005 amendment suggests that a deposit, say a check, drawn on a bank that's in the same Federal Reserve region as us, probably good after 3 days. Bank or checks from banks in different Federal Reserve region probably need to wait 7 to make sure that they're there. Check with your bank. These times may have changed, but those are the general parameters. So the rule on collected funds has been strictly interpreted by our hearing panels, meaning that our hearing panels have made it clear that a lawyer must confirm that the funds have been credited to the account before dispersing against a deposit. So for instance, in 2 of the decisions that I've included, 62 and 172, and if you want this presentation, email me and I will send it to you. And those are links. Don't start hitting on your screen right now because I don't think they'll work. But in each of those cases, lawyer expected that funds would be wired. They were real estate cases. Everything was set up for the funds to be wired to trust, and then for the transaction, the closing to take place. In each case, lawyer failed to confirm that the wire had hit the trust account and just went ahead with the closing. For various reasons, the wires hadn't hit, and the lawyer dispersed without the funds that the lawyer expected to be there being there. Each lawyer was sanctioned for violating the rules that prohibits disbursement without collected funds. There was another case that I've linked in there where something similar happened. A lawyer went to a closing, did the closing. Several different people gave the lawyer checks that the lawyer was then going to deposit into the lawyer's trust account and make disbursements against. Somehow one of the checks got left behind at the table. Lawyer didn't realize that, didn't then deposit it into lawyer's trust account, dispersed as if lawyer had. That lawyer was admonished as well. So that's why I say that these rules have been interpreted very strictly, because those are pretty, those were arguably mistakes that the lawyer made, but our hearing panels have been quite clear. So why are they so strict with this rule? Well, here's a hint. When a lawyer disperses against uncollected funds, one of two things usually happens. Either there's nothing in the account or not enough to cover the disbursement because the funds weren't collected and there's an overdraft. Or two, the bank honors the check, and as a result, the bank honors the check that the lawyer issues, and therefore, because the check that the lawyer issued was issued against a deposit that isn't there yet, that hasn't yet been collected, somebody else's money is used to carry out a different client's business. So for instance, I give my lawyer a check deposit, lawyer deposits it, writes against it, that deposit immediately without waiting for my check to clear and become collected funds. My check doesn't clear. That means that the check that lawyer writes for me, disperses against my deposit, is covered by money that belongs to other clients. And that's the purpose of the rule. It's in Rule 1.15 F2. You can't use my money to carry out another client's business. The language of the rule is there. So here's an example, again, of just a mistake, arguably not anything unethical, but a strict interpretation of the rule. PRB Decision 129. This is not unfrequent or uncommon, I mean. Many lawyers have more than one trust account, which is okay. This was, again, a real estate transaction where it was being conducted by, say, Bank A. Lawyer, staff person wrote the check out of a different trust account, one maintained at Bank B. So what happens is the people who had money in trust with lawyer, that lawyer was holding in the Bank B trust account, their funds funded a different client's closing, a client who was closing it out of the funds in the Bank A trust account. I think I just explained it pretty poorly, but the facts are right there. Anyway, be careful. It stands for the proposition that if you disperse from the wrong trust account, that means you're using money in that trust account to pay for somebody else's business. And that's a violation of the rule, our hearing panels have said. So I've made it clear, I think, that the rule is very strictly interpreted. Are there exceptions to the rule, though? And the answer is yes. The exceptions are in Rule 1.15G. So remember, the rule is don't disperse absent collected funds. Here's why there are exceptions. In 2004, the VBA's Professional Responsibility Committee issued an advisory opinion that addressed a series of trust accounting issues, one of which was this. The committee opined that trust account checks can only be drawn on client funds after the deposit upon which the check is drawn clears and becomes available. They got it right. That's what the rule said, and they interpreted it correctly. Of course, it caused some concern. For instance, real estate closings. Many of you know, at least here in Vermont, you have back-to-back closings. You sell your house, receive a check from the buyer, and you turn around and have another closing immediately where you buy a house. So what your lawyer does is take in the check from your buyer, deposit it to trust, and then immediately write against it to buy the house that you're buying. So look back. This is what the VBA advisory opinion says, that is Not good. It violates the rules because the lawyer is dispersing against the check you received from your buyer before those funds are available, literally minutes later. So we changed the rule and then put some exceptions in. Now, so these are the exceptions in Rule 1.15G to the rule that prohibits dispersing without collected funds. Lawyers in Vermont are allowed to disperse against these types of instrument on deposit. I won't read through them all. IOLTA checks, IORTA checks, personal checks, as long as they don't exceed $1,000 in the aggregate per transaction. Insurance company checks. Why these? Why do we allow lawyers to disperse against these on deposit? It's in the reporter's note. We made a decision that certain categories of trust account deposits carry a limited and acceptable risk of failure. So the disbursements against these deposits are okay immediately. So generally, we've decided that it's reasonable to conclude that these instruments are going to be good funds. So you can disperse against them on deposit. Now, remember, it's the exception, it's not the rule. You don't have to disperse against those instruments on deposit if you don't want to. You can still wait for the deposit to clear and become collected funds. That's okay. I've had lawyers call me and say, Mike, my client wants the money immediately. I want to wait until the funds are in my account. Perfectly okay. Blame it on me. Have the client call me. It's okay to be risk averse. Now, what if one of the listed instruments fails? That is, say an IOLTA check fails. The deposit isn't good. Is it an ethics violation? No, it's not, because we said you can write against that check on deposit. But what we've also said is you have to take immediate steps to protect funds of other clients that are still in your trust account. Remember, making that disbursement for me in reliance upon a deposit that fails, that means you're now using somebody else's money to fund my transaction. You've got to protect their money. And the reporter's note says you do that presumably by immediately making or securing reimbursement of the trust account to the amount of the failed deposit. So you can get your own money and put it in there. It's not commingling. It's protecting against the failed deposit. Okay, moving on. Prompt notification and delivery. That is Teddy KGB. I'll let you take a look at him because you're going to need to remember this later. Teddy KGB, character in the movie Rounders. He had one of his famous quotes from the movie is, "Pay the man his money." Well, he says it better than that. I'm not an actor, clearly. So, pay the man his money is prompt notification and delivery. That's why I used it. So here's the rule. Upon receiving funds in which a client or third person has an interest, a lawyer must promptly notify the client and third person. Very rare that I've encountered complaints alleging violation of this rule. I do have one example. A lawyer represented a client in a hotly contested dispute over a will. The lawyer resolved the matter and received over $300,000 from the estate's attorney. Lawyer didn't notify the client because what had gone on was after the decedent passed, a dispute in the family broke out. They got so bad that they stopped speaking to each other. So the lawyer knew that and preyed upon the fact that the client would never find out that the estate had actually made payment to the client. Well, eventually the client did find out. Client ended up going to some family type of reunion or holiday gathering, I can't remember which, to make amends. And they did. And people said, well, what'd you do with the $300,000 we sent you? What $300,000 you sent me? And it had been sent a year ago. Obviously, then the client contacts us. We contacted other people. The lawyer was convicted of a crime, went to federal prison, and has been disbarred. That prompted discussion in Vermont. Should we have a payee notification rule? Meaning when, for instance, an insurance check is sent to a lawyer, should the insurance company also send the check to the lawyer's client? We don't have that rule in Vermont. Again, not an issue I've run across, but when you receive funds, you have to notify your client or third person that you've received them, and you have to provide that notification promptly. Now, prompt delivery, here's Teddy KGB, pay the man his money. Money comes in and is deposited to trust. Lawyer's duty is to promptly notify clients or third persons who have interest in that money. And then lawyer's duty is to promptly disperse funds to which a client or third person is entitled, keeping in mind, of course, the collected funds rule. So that's the rule when it comes to delivery of funds: prompt notification, prompt disbursement. Prompt disbursement means we do not, by virtue of our law licenses, have the luxury of waiting until we get to it. We have to, as Teddy KGB says, pay people their money. Now, don't forget, you lawyers have to be paid as well. So there's going to be times when money comes in that goes into trust, and you have in it, some of it's yours. Pay yourselves promptly. The rule applies to you just as much as it does to anybody else whose money that is, that you have a duty to pay promptly. If you don't pay yourself promptly, we call that commingling. Now, is there an exception to the rule on promptly delivering funds that are in trust? Answer is probably yes. Otherwise, why would Mike have the slide up here? Oh wait, the answer is yes. The rule, again, promptly have to deliver funds to which a client or third person is entitled. What if, however, more than one person asserts an interest in the funds that you're holding? Here's what the rule says. When in the course of a representation, a lawyer is in possession of property in which two or more persons, one of whom may be the lawyer, just said that, claim interest, the property shall be held separate by the lawyer until the dispute is resolved. So what does that mean? What type of interest triggers that duty to hold the money, hold the funds separate until the dispute is resolved? It's not just any old claim. There are some sources of guidance. There's comment 4 to the rule, and then 2 advisory ethics opinions I'm going to mention, one from Virginia, one from Texas. Here's comment 4 to the rule. It doesn't provide a ton of guidance, and I'm not going to read it. Basically, just remember in the middle there that there will be times when the law and the rules require a lawyer to protect third-party claims against wrongful interference by the client. And when you're doing so, just remember down at the bottom there, you don't get to unilaterally arbitrate the dispute between the various parties that are asserting interest to the funds. Okay, again, not much guidance. What type of third-party claims trigger the duties to keep funds in trust until a dispute is resolved? Here's what the Virginia State Bar said in an advisory ethics opinion. That in the absence of a valid third-party interest in the funds, valid, the lawyer owes no general duty to creditors of the client and must act in the best interest of the client. And I think that's important to remember. There are valid claims and there are invalid claims. There's no duty just because somebody says, hey, the client owes me money, to keep that money in trust until you figure it out. So here's what they've said. The mere assertion of an unsecured claim by a creditor does not create an interest in funds that you're holding. Therefore, claims unrelated to the subject matter of the representation, though they might be just claims, they are not sufficient to trigger duties to the creditor without a valid assignment or perfected lien, for example. So that makes sense to me. And here's the example I've used. So let's say a client was injured skiing, and the ski area's insurer settled for $100,000 that is now in the lawyer's trust account. Client's skiing injuries resulted in medical treatment. Lawyer and client know that the med provider has a lien on any recovery. When the money comes in, that triggers the duty to notify to promptly notify the medical provider, because the medical provider's interest is in those funds. The medical provider provided services for the injuries that resulted in the client receiving that payout from the insurance company. So it's related to the representation. This claim by the painter that I'm about to talk about is not. So shortly before a client was injured in the skiing accident, painter painted client's house. Why did the painter paint the house in the winter? Must have been an interior paint job. Anyway, Client disputed the bill and has yet to pay it in full. Painter has never sued client or obtained a judgment against client. Somehow, however, painter found out about the ski injury settlement, let lawyer know, and directed lawyer to hold in trust the amount that painter contends is owed by client. That does not trigger any duties under the rule. That is some sort of unsecured claim that is not related to the representation that resulted in the funds that are now in lawyer's trust account. Here are some examples of instruments or triggers under the rule: liens, court orders that affect directed at the funds. The Virginia State Bar also reminds that the lawyer doesn't have to be a party to, for instance, an assignment or a lien or a letter of protection, but if the lawyer is aware that the client is a party to one, that might be sufficient to trigger lawyer's duties under the rule. Virginia also reminds that there may be under federal and state law obligations imposed upon lawyer and client depending on the medical treatment that client may have received from particular providers or pursuant to particular health plans, where the duties under the rule are triggered even absent a lien or a lien letter. So basically, competence includes knowing the substantive law. The Texas advisory opinion was issued last spring, or last June, I think. Professor Bernabe, who I've mentioned before in these videos, he's got a great blog, the Professional Responsibility blog. Check it out. He blogged about this. Texas Bar Ethics Committee opinion, called my attention to it. Thanks, Professor. The Texas opinion addressed two questions. Number one, when does a third party have an interest in client funds that's sufficient to trigger the lawyer's duty to safeguard those funds for the third party's benefit? And number two, does the termination of the attorney-client relationship affect a lawyer's duty to safeguard client funds in which a third party is asserting an interest? The answer to the first question is the duty is triggered only when a third party has a matured legal or equitable interest in those particular funds. So again, very similar to the Virginia opinion, the painter's claim is not a matured legal or equitable interest in those particular funds. Won't read through all these. Again, it's what the Texas Bar Ethics Committee listed as meeting the definition of a matured legal or equitable interest. So those are the types of notifications you would receive or documents you would receive that would trigger a duty to safeguard a third party's interest in client funds. The second question, well, the client fires you because you are holding in trust funds to which a third party has asserted an interest. Obviously, that would just eviscerate the rule if that meant you would then have to give all the money to the client. So the Texas Bar Committee said that the duty survives even if the client fires you. Obviously, I don't know how the Vermont Supreme Court or one of our hearing panels would decide this issue. We've never had to litigate it. The issue of a lawyer either not dispersing to a client a portion of funds in which a third party has asserted an interest, or the issue of a lawyer dispersing all the funds to the client, even over a valid third party claim. But I will say this, Vermont's rule, while not verbatim, is very, very close to the rules as drafted in Virginia and Texas. Okay, so let's go through the answers to the quiz. Question one, the specific phrase is collected funds. That's why this seminar was entitled Collected Funds and Disbursing. Two, the rule that says don't disperse without collected funds, our hearing panels have been very strict. And every hearing panel decision, if it doesn't get appealed within 30 days, becomes a final order of the Vermont Supreme Court and has the full force and effect of an order of the Supreme Court. So our court's been strict too. Cannot write against a personal check in the amount of $1999.99. It exceeds $1,000. The others are instruments that are listed in 1.15G. as exceptions to the general rule that prohibits disbursement absent collected funds. Question 4, the purpose is to keep lawyers from using my money to pay for my brother's business. Yeah, we each have lawyers. It's just how it goes in our family. Question 5, lawyer must promptly notify the client or third person. That's the Teddy KGB rule. Question 6, false. Lawyer says, that's my earned fee. Client says, no, it isn't. Funds stay in trust until you resolve the dispute. We are not exempt from the rule. Question 7, this is the painter. The mere assertion of an unsecured claim by a client's creditor does not trigger the lawyer's duty to keep the funds in trust until the dispute is resolved. Look again to those ethics opinions from Virginia and Texas as to things like statutory liens, assignments. Those are what trigger the rule or trigger the duty. Okay, we've made it through to the bonus question. Hope the seminar was helpful. So I referenced the movie Rounders and a character named Teddy KGB and one of his more famous lines, pay the man his money. Who played Teddy KGB? That's bonus number 1. And number 2, who played the law student whose interest in poker introduced him to Teddy KGB and kept him from paying much, if any, attention to law school? Give you a couple of seconds to sort through that. This is going to be the third in a series of trust account videos. I think I'm going to do one more where we talk about flat fees, that rule, which is a relatively new rule. Misappropriation, which won't take me long. It's essentially don't misappropriate. And then I'll go over some of the more basic trust account scams in the final CLE. So who played Teddy KGB and who was the law student who didn't go to class to play poker? John Malkovich and Matt Damon, which brings me to the final slide. Well, 2 more slides. The pop culture icon of this segment. I'm not going to go with John Malkovich or Matt Damon. I'm going to go with Gretchen Mol. She played Matt Damon's girlfriend in the movie. She actually went to class and presumably became a lawyer. So, as bar counsel, I can't make Matt Damon the pop culture icon of the segment because he didn't go to class. Competence comes from actually going to class. So that's why Gretchen Mol and her character are the pop culture icon of this segment. And finally, if you need the link to the forums, there it is. Or you can email me and I'll send it to you. Again, it will ask you for your email address. And once you answer the questions and hit submit, it'll spit back a response with an explanation of the answers. I am not grading them. I don't even look. The reason I ask for your email address is to, again, make sure that the response goes to you. So that's that. I'll leave it up for one more second. Thank you all. I hope you're all doing well. Continue to do well. Again, any questions, give me a call or send me an email, michael.kennedy@vermont.gov. And thanks again. Have a great day.